Good morning, everyone. Welcome back to this latest episode of the Free Marketeers podcast. I hope you're all doing well. On this Friday, the 6th of November, there's a small something happening in the United States of America. I'm sure you're all focusing on that news, but for the rest of us here in South Africa, we have a lot to deal with, as always, with our government, and there are many plans going on. Today, we're going to talk about something that I think should best be placed in a science fiction book. But again, when it comes to the South African government, we shouldn't be surprised that they plan these sorts of things. My name is Chris, and my guest today is Gary Moore. Gary has had a very long relationship with the Free Market Foundation. Gary, thanks so much for being here.
Good to be here. Thank you very much for inviting me, Chris.
Gary, I thought we'd just start off giving you a chance to give a little bit of your background with the FMF. As I mentioned, a long association and relationship. So I thought if you could give us a quick overview there before we get into the actual topic of today's episode.
Great. Well, I've known the FMF and Leon Lowe in particular, and since about 1990. So, and on a social basis as well, I'm happy to say. Mm-hmm. It's a very pleasant organization to work for, and I look forward to many more years.
And Gary, I know this is very broad, but your sort of area of interest is broadly the rule of law. You do submissions and articles and that sort of thing.
That's right. I'm an attorney by background, and I have practiced for 30 years over there in South Africa, and I do submissions for the Free Market Foundation, usually of a legal kind.
And we have to mention that Gary is talking to us from Australia, so he's going above and beyond here in his giving up his Friday evening to talk to us today. So thank you, Gary.
I'm happy to say that I keep very much in touch with South Africa and all its laws, for one thing, and good friends in South Africa, including your good self, I hope. So, and I hope that continues for many a year.
Yes, definitely. No, but again, thank you for being here. Okay, let's get right into it. So today we're talking about the sports bill. Gary, you wrote an article for us. For any viewers and listeners, you can find that on our website, that article, if you'd like to read it. It'll be under the rule of law category on our website, www.freemarketfoundation.com. So Gary, the sports bill, I thought we'd start with the overview. What is this bill all about? What does it envision? And then we can get into a bit more specific questions, I suppose.
Well, this will amend the Act by establishing a sport arbitration tribunal and provide a procedure for bidding for and hosting international events, and to create offences and penalties. But a lot of the grim stuff was already done in the Sports Amendment Act of 2007, which amended the Principal Act of 1998 to fairly closely regulate sport. And I'll talk about that later, because I think we're going to talk about examples applied elsewhere in the world. So that's good to refer back to the Sports Act of 1998 and see how the legislation with certain foreign laws. So on I go. What to say? The draft bill will amend the Act to provide that the Minister may determine policy objectives to be achieved by the Department of Sport and the Sport Federation, which is a state body regulated under the Sports Act as amended, and by sports bodies. So the nub of this is the Minister may, in his discretion, determine policy objectives to be achieved by sports bodies. Well, this violates the rule of law in being vague and unfettered. It doesn't make clear to what extent these policy objectives would bind sports bodies and others, and nor does it restrict the scope of any policy objectives that the Minister might determine. It gives an unfettered power to the executive to determine these policy objectives.
Gary, just to jump in there quickly, sorry, when you talk about the sports bodies, I mean, you're talking about the South African Rugby Union, Cricket South
Yes,
Africa,
the
that sort of
sports
thing.
associations, the Cricket Association, the Football Association, etc.
Okay. It's not like Cricket South Africa is in a mess already anyway, so why not add more government oversight and interference?
Well, I will illustrate some of that just now,
Well,
particularly in connection with uh, examples elsewhere in the world.
okay. So you mentioned the unfettered aspect. Are there, I thought I would ask you specifically, what are the three main rule of law specific concerns?
Well, I think that one's the first one. It's
Hmm.
an unfettered and vague empowerment clause to impose policy objectives
Okay.
on sports organizations. The second one of the three would be to amend the Act to provide that sports bodies must ensure that selected players comply with a national call to participate. This is vague. It could mean that you have to turn up for national team training and matches. And it's also, if that is so, it's also compelling players to comply,
Right.
even unwilling players. And that then violates, you might say, the rule of law in subjecting people to forced labor of a kind.
Hmm. Yeah, when you talk about a national a sort of call, it sounds like we're in a time of war.
Yes, it does. A call to arms. Well, that's another thing about sport. People think it's government property, as I will point out to you just now. The third thing, you asked me what are the three main rule of law specific concerns. The other one is that the bill would insert in the Act a new provision which would create offences and specify penalties and say that a convicted person would be liable to a fine or imprisonment for up to 20 years. Now, this is just a sports law, by the way, or both. And the current maximum fine that may be imposed as an equivalent or alternative to 20 years imprisonment is 800,000 Rand. So 800,000 Rand, perhaps not a lot in today's money, but or 20 years in prison. And one of these offences would be failure to comply with the new requirements about having foreigners play in the Republic. They say that a sports body must, before recruiting a foreign sports person to participate in formal professional sport in the Republic, have to satisfy themselves that no one in the Republic is suitable, verify the foreign person, ensure that the recruited foreigner has represented or coached his or her country in a manner prescribed by the minister. And if you don't do all that stuff properly, you could be liable to 20 years in prison. So that's unduly harsh. And the rule of law requires that laws protect fundamental rights, which include the right not to be subjected to cruel punishment, which I think 20 years for an administrative lapse in a sports environment is cruel and unusual punishment.
No, I would imagine. We talk about, sorry, I was just going to say, we talk about other examples of South Africa not being that, I don't know, foreigner friendly with stuff, around townships and regulating of businesses and that sort of thing. But I guess this just, again, reinforces that sort of perception that maybe we're not that friendly to foreigners.
No, it does seem so, particularly in a dimension like sport.
Yeah, and you'd think we'd want experts from all over the world to come here and coach players and help local coaches and that sort of thing, give their input, that kind of thing. I would assume it's good to exchange expertise. I mean, the Australian Rugby Union appointed a New Zealander as their coach now. Not that it seemed to work at this past weekend, but there's a mixing of ideas and stuff. I don't know.
Maybe the New Zealanders sent him over.
Maybe that's what the South African government is worried about. They need to protect us from outside agents.
Yes. So yeah, certainly they seem very concerned about protecting local jobs in sport to the tune of 20 years imprisonment. And I got.
Oh, sorry, go ahead.
I've got some notes here on equivalent or sentences for other crimes. For killing third party in an altercation is 12 years imprisonment. That's been imposed by the courts. For insurance fraud, the courts have imposed 5 years imprisonment with 2 years suspended. For attempting to bribe a police officer, a person accused of possessing half a ton of dacha for sale, induce the officer to testify at the dacha possession trial in such a way that the accused would be acquitted with 3 years imprisonment with 1 year conditionally suspended. And for receiving 190,000 cigarettes, knowing them to have been stolen, 18 months imprisonment. Mind you, these are minor offenses compared to administrative ones about sportsmen and women. 20 years is fine.
I don't know what else to say except like insanity and craziness. That's how it's coming across to me. What, with this sort of stuff, what rationale do they give in the bill? Is there any way that they try and justify some of these things that jumps out to you, or is it the usual stuff of, the government? It's simply assumed that the government needs to be involved in sport.
Yes. Well, that comes out of the 2007 Amendment Act, which has already been passed. And that act had a preamble that says that sport belongs to the nation, whatever that may mean, and that its administration, however, has been entrusted to sports bodies implicitly by the government. So that's a sort of a government privilege that it gives to sports bodies. Here, you can run the sport if you behave. And that government, says the 2007 Amendment Act, has a constitutional obligation to ensure good and responsible governance of sport. And any sport malpractices, therefore, necessitate government intervention. So the rot had already set in 2007. That 2007 Act has its own vague and rule of law problems. It says that the sports minister must recognize a sports confederation to coordinate activities relating to high performance sport, which is defined as high level participation in major international sports events, including international multi-sport events such as the Olympic Games. Despite this definition, it's still vague. It doesn't tell you what high-level participation or major international sporting events mean, whether they involve only 2 countries or 1 sport as opposed to multi-sport. And all this violates the rule of law in not being clear.
So that's one thing I'd like to highlight. Hopefully I'll remember later as well. Whenever one has a new bill being drawn up or something enacted, from the rule of law perspective, right, you always want the language and the concepts to be as specific as possible. You don't want any vagueness for interpretation. Then you get into the problem of ministers exceeding their powers, right?
I'm getting the impression that the state law advisors put their junior person on the job in these, when it comes to sports legislation. It's full of ambiguity and poor drafting. This new bill is not well framed at all.
Do you, I wanted to ask, do you know any impressions, not that you would have had to have researched this in depth, but any idea about what international organizations or bodies would say about this sort of thing?
Well, I'm glad you mentioned that, because back to the 2007 Sports Act, where I think they looked at foreign practice before they wrote it. They said, the amended act says every sports body must resolve disputes among its members or within its governing body, and tell the minister about the dispute. If the dispute is not resolved, the sports body or any aggrieved member may submit the dispute to this new statutory sports confederation, which must tell the minister, invite parties to make representations, convene a necessary inquiry, resolve the dispute, and tell parties of its decision in accordance with the Promotion of Administrative Justice Act, as if this is a public law decision. And the thing about administrative action, though, it only kicks in if the person concerned has been exercising a public power or performing a public function. And I say that even the sports confederation established by law is not exercising a public power or performing a public function.
Right.
The court say public power is something that may impact on the interests of the community, and a public function is a function of being engaged in affairs or service of the public. But I doubt if decisions of a sports confederation, even if established by law to resolve disputes among members of sports bodies, whether regarding amateur or professional sport, is the exercising of a power which may impact on the interests of the community or involve being engaged in the affairs or service of the public. So that's what I say. However, the Supreme Court of India seems to have a different view.
Okay.
About in 2013, there was a match-fixing scandal involving the Premier League, the IPL, and it reached all the way to the Supreme Court, where their reasoning was that because of the Board of Control of Cricket in India is a very wealthy and you might say powerful organization, it's the richest cricket body in the world.
Right.
Even richer than the English and the Test and County Cricket Board of England and Wales. It runs cricket to the exclusion, says the Supreme Court of India, of all others. But they have no statutory power to stop others from setting up rivals.
Right. So is they concerned that they're like a monopoly, you know?
Yes.
Okay.
So they say that the BCCI can fairly be described as a body that's not merely undertaking a private activity, but practically performing functions of the state. And so it lends itself available to a certain interdict procedure in a section of the Constitution of India. I must say this was clearer to me from the commentaries I read than from the Constitution itself. But therefore, the Supreme Court had jurisdiction to issue mandamus and appoint an investigating committee to establish certain facts and levy certain fines and so forth. And that's an example, again, of a government interfering. But they did it through the judiciary. Even though I must say I'm not convinced by the reasoning. And that the Supreme Court of India also referred to a Supreme Court of the United States decision called Marsh versus Alabama, I think 1946. Okay. And in Marsh, she was a Jehovah's Witness, was Marsh, and a prosecution was launched against her for refusing to leave the sidewalk of a private town. In other words, it was a private township with that owned the streets itself. It was a private corporation. It wasn't a state or recognized municipality.
Okay.
But that way. So this private town said, we're private property. We can decide what's allowed on our streets.
Sure.
And she said, I don't want to leave the sidewalk. I want to distribute religious pamphlets and exercise my religious freedom under the Constitution. And the Supreme Court agreed with her, and they said that the more that a town, that an owner for his advantage opens up his property for use by the public in general, as this private township did, the more do his rights become circumscribed by constitutional and statutory rights of those who use it. So really what they're saying there is you're not all that private, always. So that was that case about exercising constitutional rights. And so between that and I have to say a lot of the language of the Board of Cricket of Control for India case versus Cricket Association of Bihar seems to have been brought forward into some of this legislation, the sports bill. I think that's where they're getting their inspiration from, those judicial decisions, not from any statute.
So we want some foreign input, but just not other foreign input.
Yes, that's right. We like foreign influence if it allows us to enact a sports bill to keep foreigners out.
Gary, I wanted to ask you, this bill, does it just focus on the sorts of bodies that we think of like cricket and rugby, or does it also include anything on, your local community clubs, your darts club, your pool club, that sort of stuff?
I have a note on that, if I can, while calmly talking to you, find it, that he's desperately searching.
Because I was wondering, if it shouldn't surprise me that the government would want to control every single thing, down to the community level. So
it's poorly drafted, as I say, and it's going to give the minister the power to approve applications for the hosting of major international sports, prescribed international events and international sports events. So 3 inconsistent phrases, but it's quite clear there that that's an international dimension, and it's not necessarily the case that it gets down to local clubs.
Okay.
Although the inspiration is there to do it, because sport belongs to the nation.
Yeah. And whenever something belongs to the nation, I'm assuming the only body that can interpret what the nation wants is the government.
Yes, in their wisdom. In fact, that's their logic, that any sport malpractices, although they tend to notice only the ones in the national controlling federations and so forth, necessitate government intervention, said the 2007 Act.
Right.
But so the smaller bodies might escape there.
Okay. Well, one can only hope that there might be some sort of escape of some sort.
Yes.
I wanted to ask as well, this is I know again a broad question, but if you want to focus on 2 or 3 things, what number of effects could this bill have if it became law, do you think?
Well, besides these uncertainties that I've spoken about there, there are others, other uncertainties about possible criminal offenses that people might be subject to, although it's not sure. Here's one that says, the bill would say that sports bodies must ensure that a person who doesn't comply with the obligations of the international controlling body is guilty of an offense and liable to a fine or imprisonment for 2 years. Well, at least that's a moderate. But what does that mean, the obligations of the international controlling body? Do they mean obligations imposed by the international controlling body? In other words, to join in international competitions or something like that, drafted, but also it says in saying that the sports bodies must ensure that a person who doesn't comply is guilty of an offence. Are they trying to imply that if the international controlling body says you must take part in national team training and matches, commits an offence, that's for the forced labour clause again? So more of the same. And
I also wanted to ask you about, do you think this could also have an effect of simply dissuading people from playing sport, high-level sport, if it means, they're going to be sort of controlled to this extent? Do you think South Africans, with a lot of talent and that sort of thing, they're simply not going to play these sports?
That might be so if the sports concern become poorly administered by ultimately the sports confederation, yes.
Okay.
Where there's something demoralizing about having an outsider come in and tell you how your sport should be run, as if they know everything, particularly a government organization.
Okay. So I'm assuming we can expect things to go in that direction, given what's happened in cricket South Africa, especially.
Yeah, I mean, I'm thinking of in certain perhaps not so much as football in England, where the teams have many foreigners, but it's raised the standard of the game. I mean, it's still become, it is the, I think it's the premier, most watchable soccer tournament in the world. And any government intervention like this will have consequences, adverse consequences.
Yeah.
And this can only speculate.
Yeah. Yeah, Gary, we could always come back to the sports bill, but I did want to make sure that we also in this episode just covered something else that you've worked on in the last month or so for the FMF. You led evidence before the Portfolio Committee on Transport regarding our submission on the economic regulation of transport bill. So again, just more regulation. Can you tell us a bit about this bill and about your, that you led evidence on it? What does this bill envision?
All right. Well, briefly on this, the purpose of this bill is to promote the economic growth and welfare of South Africa by promoting an effective, efficient, and productive transport sector. So it's very optimistic. And to that end, to establish two parallel, independent, but integrated regulatory agencies. So the more you regulate it, the more efficient and productive it will be, this transport sector.
No, that makes perfect sense. The one thing I think South Africa needs heading out of COVID-19 is more regulation.
Yeah. And so there were a range of interested parties making submissions. The one I want to point out is that the memorandum on the objects of the bill says something that seems to shoot the bill in the foot, rather, which is that, I don't know what this guy was thinking, or was he allowed to get away with it, but it says, preconditions for efficiency and cost effectiveness do not exist in the South African transport sector. And in particular, the institutional framework of transport is dominated by large state-owned companies, which have a very high degree of market power over the infrastructure or services which they operate. So it's blaming the state for the inefficiencies, not any private sector abuse of market power, so to speak. So one of the points I raised there is that, well, large state-owned transport companies should then be broken up and privatized, do away with the need for the bill at all. I made the main point to the committee that the bill as a whole will impose undue restrictions on the transport sector and should be withdrawn. And I'm relying on the Free Market Foundation written submissions of July to the Transport Committee about this bill as well, and for framing my presentation. There's a clause that says the Minister may declare the Act applies to any market in the transport sector if he's determined that a single operator controls more than 70% of the market. So it seems kind of arbitrary.
Yes.
To be 70, why not 1% or 99%? Clause 4.2b says the Minister may declare the Act applies to any market in the transport sector if the Minister has determined that the preconditions for efficiency and cost effectiveness do not exist in the market concerned. Well, the explanatory memo on the bill says flatly the preconditions for efficiency and cost effectiveness do not exist in the transport sector. So this is automatically the case that the Act will apply to these inefficient state-run sectors.
So this bill can cover anything from the Gautrain to Uber to the taxi industry?
Yeah, in theory, that would be the case.
Okay. We know, of course, government would like to crack down more on Uber, so I suppose it makes sense.
Yeah, that's they don't like. That's a completely more or less unregulated business, or rather, numerous micro businesses.
Yes, yeah. I thought we were supposed to encourage micro businesses.
Yeah, and there's, I was going to say an umbrella facilitator, but I don't think that the booking system is an umbrella as such. It's just a facilitator, rather like the one we're using now to speak to each other. There's a clause in the bill that says when making a determination that the Act applies to a market in the sector, the regulator or the minister, it's not clear who should this should be. There are drafting lapses in this bill. Must have that at least one firm operating in the market has market power, which the bill defines as the power of an entity to control prices or exclude competition, or to an appreciable extent behave independently of its competitors, customers, or suppliers. But these, as pointed out in our July submission, every firm in every market has a power to control prices.
Yes, of course.
Because there's no such thing as perfect competition in the real world. But I don't think that the Department of Transport is aware of the real world.
No. I guess this is, sorry, I was going to say, just in terms of the history of regulations and governments, they always presume that they have this enlightened insight into they can create a utopian market.
They can do it better. Yeah, and again, to make such a determination that the Act applies to a market, the regulator must have found that at least one firm operating in the market has market power, also defined as the power to exclude competition. But every firm has power to exclude competition to some extent. By purchasing or supplying resources, they exclude other firms from doing so, only temporarily. It's not all black and white, contrary to what all the legislation, such as this and the Competition Act, seems to believe. On market power is also defined as the power to an appreciable extent behave independently of competitors, customers, or suppliers. But market entities never behave independently of their competitors, customers, or suppliers. It's a market, for God's sake. Sorry.
No.
Strong language, but yes.
Isn't there also, this is now getting, again, abstract and a bit more philosophical, but I guess the only real monopoly that can exist is a government-enforced or protected monopoly.
Yes, because all the others are not really monopolies. They are always at threat of new market entrants coming in, undercutting them on price or improved supply, whatever. So not true monopolies, only statutory ones are.
Right. And then, Gary, I think before we start wrapping up, I just wanted to ask where, between the sports bill and the transport bill, where do they sit at the moment in the process? Is there any sort of idea you have about when they could be enacted, that kind of thing?
That I cannot say. On the transport bill, I can tell you that it was as introduced in the Assembly. The other one, I can tell you something about that because there was some shambles about introducing it.
That's par for the course.
The sports bill was first introduced in 2018. A sports amendment bill, a sports and recreation amendment bill. Mind you, back to regulating sport as small bodies, it does deal with recreation as well. So the intention of the government is to get quite wide there. But the 2018 sports bill was then, after its first reading, referred to the Sports Portfolio Committee, but then the President dissolved the Assembly in early 2019 before the committee had completed its report. So the bill lapsed according to National Assembly rules. And then there was a national election in May last year, 2019, and then for a new Assembly term. And in early January 2020, the Minister gave notice of her intention to introduce once more a bill to amend the Act. And this bill is the one I've been talking about. It's identical to the 2018 amendment bill that lapsed. But at this stage, it's just in, you might say, a draft form, not in the final form that parliamentary bills are presented usually to the assembly in, but that's because they're going through the same motions as before.
Right. Okay.
That's the only reason for that. They expect it then to go to committee, but so they're all early stage at this stage. The sports bill, perhaps more so, even though it was a more senior bill in any way.
I probably already know the answer to this, but I should ask in any case, was any sort of socio-economic impact assessment done around either of these bills? Do you know?
Lay me down, I would say,
I know that's no guarantee, but you know.
Of transport bill, they would usually record this sort of thing. And that didn't come out to me at all about a socio-economic impact assessment in either bill. So I panicked for a second saying, oh, I didn't notice that. And that's the reason that I didn't see it.
Okay.
They didn't.
Okay. Yeah, I suppose that's also par for the course nowadays.
Yeah.
Oh, all right. Gary, I think Sorry, go ahead.
No, carry on. But one thing on the transport bill, I want to ask pertinently by someone in committee, what about competition, the overlap of the Competition Act? And there is. It's just they're going to deal with a regulator to create this regulator who will do things that now there's the Competition Commission does. And often in words exactly poached from the Competition Act.
That flippin' Competition Act. It seems to pervade everything.
That's another thing, for a story for another day, perhaps.
Yes. No, I'd love it if we could get into more competition and competition regulation and aspects in South Africa. I think there's a few other areas of interest the FMF also covers that we could definitely talk about in future episodes.
Good. In connection, say, with telecoms.
Yes. Yeah, definitely. And the digital economy. But Gary, I think on that note, we've sort of covered quite a bit in this episode. I know for me, especially personally, it's not always the most uplifting to cover the subject matter, but it's important that we inform people about it. That's part of what the FMF sets out to do every day. So I want to thank you again.
You've got to have a good laugh about it as you do it, otherwise you go crazy.
A good advice for all of us, I think. Any last parting thoughts from you?
No, just we fight the fight, continue to fight the good fight.
Yeah.
Never ends.
No, I agree. The price of liberty, you know, what is that quote? It's at least vigilance. Yes, there we go. Vigilance is eternal, yeah. That's the best we can do. And viewers and listeners, we also, again, have to thank all of you for your support. Please continue sharing our articles, our submissions, our media releases, everything. Please like this video. Please share it as well on your different social media platforms. We greatly appreciate your support, especially in this crazy year that is 2020. All of your support means a whole lot to us, and it makes the fight that little bit easier knowing that there's many of you supporting us in the ideas we try to put out there. Gary, I want to thank you again for your time today. I hope you have a good weekend. And I think...
Undiluted pleasure. Thank you for inviting me.
Really a pleasure, and I hope we can do many more of these going forward. Everyone, to you, thanks for your time. As I say, have a good weekend, and we'll have a few more episodes out for you next week. But for now, we'll say bye-bye.